A very good morning, class. Can you all hear me? I mean, a very good afternoon. Can you all hear me?
Good afternoon, ma'am.
Good morning. Good afternoon, I would say. Okay, so today we are going to continue with the Payment of Wages Act. Okay, I believe we have already started with the Payment of Wages Act. We have done the introductory part, right?
Yes, ma'am.
Yeah. So till the time people join in, let us quickly revise whatever we have studied, and when people, the rest of them join, or the rest of the students join, then we will start with the new provisions. Okay. So let us quickly revise. Okay. So there's still, I think, there's 3 students here, still in the class. There's three students. Let us wait for others to join in. Until then, let us quickly revise, okay? So, can you all see my screen, the PPT?
No, ma'am.
Oh, just a minute. Okay, can you see it now?
Yes, ma'am.
Okay, so we had started with the Payment of Wages Act. Okay, so and we had studied about why this act is so important. What was the reason for the enactment of this particular act? Right, we studied about it. Can anyone tell me what was the reason, or why do you think it is important to study this act? Can anyone tell me?
Ma'am, for timely payment of wages.
Very good, for the timely payment of wages, right? To make sure that the employees are not exploited. In what way? That the wages are paid. There are no unnecessary deductions from the wages, right? Unnecessary deductions mean it can be in the way of fine, it can be in the way of any kind of penalty, right? To make sure that whatever wages the employees are bestowed, they are given that much of wages, and there are no unnecessary deductions, right? Because we had seen that when industrialization had started, obviously the employer used to hire the employees, right? And there used to be unnecessary deductions from the wages, right? So even if they were said that they are going to get wages of say 1,000 rupees, from that also there used to be unnecessary deductions as penalty. So in hand, the employees just used to get say around 400, 500 rupees, right? So to make sure all of this does not happen, this act came into force. Okay, so the main objective we know is to avoid unnecessary delay in the payment, right? To prevent unauthorized deductions, right? So this is the main motive, main object of this particular act, right? Then we have studied that this act is going to be applicable where it is going to be applicable to those persons who are employed in a factory, in a railway, in any industrial establishment as well, right? And also, most importantly, it is going to apply to those employed persons who are drawing an average wages which is not exceeding 10,000 rupees per month, right? So this particular act is applicable to those employees. Is this clear? Is this clear, students? We are just doing a quick revision, a quick recap, so that it's all fresh in your mind. Are you all with me?
Yes,
Are you
ma'am.
all with me?
Yes, ma'am.
Great.
Yes, ma'am.
Then we had studied about the important definition of who employed person is, who is an employee, what is wages, right? We had studied about these important definitions. Then we had studied about the responsibility for the payment of wages. Like we've seen that obviously there is going to be a certain person who is going to be responsible for the payment of wages, right? So we have studied earlier that when it comes to factory, it is going to be the manager who is going to be responsible for the payment of wages to the employees. When it comes to industrial establishments, in that case scenario, it is going to be the supervision who is going to be responsible for the payment of wages to the employees. And in case of railways, we know that it is going to be a person nominated by the railway administration who would actually be responsible for the payment of wages to the employees. Is it clear?
Yes, ma'am.
Yes, ma'am.
Okay. Just a minute. Okay, so furthermore, we had studied that when it comes to a contractor, in that case scenario, it is going to be that person who's designated by such contractor who would be responsible for the payment of wages to the employees, right? So now we know like who all are going to be responsible person who will have to pay wages to this section of people, correct? Now going furthermore, just a quick recap, we had studied about fixation of wage period as well. Can anyone tell me about the fixation of wage? Can anyone tell me about the fixation of wage? Can the wage by the can the responsible the employer, can the wage be paid say after a year's time frame? Can it be paid after 6 months, 7 months, 3 months?
No, ma'am.
No, ma'am.
Why? What is the problem?
Maximum time period is 1 month.
No, sir.
Very, very good. The wage should be paid within a month period time. It can be daily, it can be weekly, it can be fortnightly. Okay, it can be monthly as well. But it cannot be more than a month. So the wages must be paid within a month's time frame. Is this clear to one and all?
Yes, ma'am.
Is it clear?
Yes, ma'am.
Okay. Now let us go ahead. Let us talk about the time of payment of wages. Can anyone tell me in regard to the time of payment of wages? Within what time frame the wages should be paid?
If there are by the 7th day, if there are less of 1,000 employees, then the 7th of the respective month, and if there are more than 1,000 month, and then the 10th of the respective month.
Very, very good. Very nicely said. So we know that the wages must be paid timely. Okay, there should not be delay in the payment of wages. So we know if there is any kind of establishment, it can be factory or any industry, and if there are less than 1,000 employees, then in such case scenario, the wage must be paid before the expiry of the 7th day of the next proceeding month. And in case of any establishment where there are more than 1,000 employees, then in that case scenario, the wage must be paid before the expiry of the 10th day of the next preceding month. Is this clear? Is this clear?
Yes, yes.
Yes, ma'am.
Yes. Now let us go ahead. Again, this is a quick revision in regard to mode of payment of wages. Now, can anyone tell me what can be the mode or the medium of the payment of wages? What can be the mode or medium for the payment of wages?
Ma'am, cash.
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 Cash. Very good.
Check, coins, check.
It can be coins. Very good. Can it be those currency or coins
Can
which
it be check?
come again?
Cash,
Pardon me?
check, bank account, coins.
Good. So definitely it can be cash, it can be coins. Can it be those cash and coins which are no longer used, which are no longer being used? Can it be those cash, currency, notes and coins?
No, ma'am. No, ma'am.
No. So can I say those currency coins which are in use on a present day, that can be the mode of payment to the employees as wages? Can I say that?
Yes. Yes.
Yes. Can there be okay? So definitely currency notes or coins which are being currently used as a medium of exchange, definitely they can be used as a mode of payment of wages. Now, not only currency notes and coin, can check also be used as a mode of payment of wages?
Yes, ma'am.
Yes. How about directly crediting the wage into the bank account of an employee? Can that also be allowed?
Yes, ma'am.
But what
Yes,
is
ma'am, but-
necessary?
Written authorization.
Written agreement
From the
of the employee.
Very good. Written authorization of that employed person is necessary and mandatory if the mode of payment of wages is by way of check or by way of directly transferring the money into the bank account, right? So now we know about mode of payment as well, okay? In our previous, let me see, has everyone joined in? Has everyone joined in? I think there are 8 students, right?
Yes, ma'am.
Okay, I think now we will start. In our previous lecture, I believe we had started about deductions. Do you all remember? We had studied about deductions in our previous lecture.
Yes, ma'am.
Yes, ma'am.
Right. Can anyone tell me what do you remember about deductions?
Ma'am, lawful reduction in wages in terms of fines and penalties.
Okay, so we know that deductions means whatever the wage is there, right? Wages of the employees are there. From that, okay, if there are any kind of money which is being reduced, right, from the wages, that is nothing but unauthorized. That is nothing but deductions, right? Now, deductions can be in the form of fines. It can be in the form of penalties as well, right? So, and we have studied that there are certain, deductions which are not considered as illegal or which are not considered as deductions at all. Can you give me example of those kind of deductions which cannot be said that they are deductions at all? Yes? Can anyone
Ma'am,
help me?
causing willful loss to the organization.
Okay. So tell me one thing. Now, if in an industry, okay, if the employer is stopping the increment of an employee, will that be considered as deduction? Again, I will repeat. If in an establishment or in an industry, right, if an employer is stopping the increment of any employee, will that be considered as deduction?
No, ma'am.
No. So that is definitely not deduction. Okay, in case of any demotion of an employee, will that be considered as a deduction? No. Again, that is not a deduction, right? So, how about stoppage of the promotion of an employee? If the employee is not promoted, will that be considered as a deduction?
No, ma'am.
No, ma'am.
So these are definitely these examples definitely don't fall into the category of deduction. So what is deduction exactly? Okay, so deduction, every amount which is paid by an employee to his employer is going to be called as deduction. So any amount which an employee, okay, is compelled to pay out of his wages to the employer is definitely going to be considered as deduction. Okay, so definitely stoppage of increment of employee is definitely not going to be considered as deduction. Then demotion of an employee is definitely not going to be considered as deduction. Moreover, in the stoppage of increment, that is also not going to be considered as deductions, right? So now this definitely is is not going to be considered. But there are certain deductions which are lawful, right? I believe we have studied about those deductions as well. Do you all remember? Do you all remember the deduction? Can
Yes,
you
ma'am.
give me an example? Can you give me an
Ma'am,
example?
absence from duty.
Correct. So if there is a
Any
person,
damage or loss of goods.
very good. Okay. Okay. Very
If
good.
any service provided by the employer.
Good service provided by an employer. Okay. So
Ma'am, deduction for HRA.
deduction for
HRA, house rent allowance.
yes. Very good. Yes. HRA. Yes. What else?
Deduction by order of a court.
Very, very good. Deduction by an order of court. So we know that these deductions are going to be considered as lawful. They are legal deductions. Okay. So now, by the Payment of Wages Act, okay, there are certain deductions which are considered lawful. Okay, which has been provided under Section 7. Okay. So now we are going to study. We already have studied overall what are the deductions which are considered as lawful deductions, which are considered as lawful in the sense that if the employers are deducting wages for all these reasons, then definitely those deductions are going to be considered as valid. Okay. Now we are going to study each deduction very properly. Okay. Can you all see my screen? Can you all see the PPT?
Yes, ma'am.
Okay. So the first one that we have, which we are going to study, is about fines. Now, are fines considered to be a lawful deductions?
Yes, ma'am.
Correct.
Yes, ma'am.
So yes. So now we know fines are considered as lawful deductions, okay? But in what circumstances? To what extent? Okay, so now let us read that. It says that the wages of an employed person must be paid to him without deductions of any kind, except those authorized under the Payment of Wages Act. So illegal deductions definitely are not allowed. Okay, before the enactment of this act, we used to see that there used to be an illegal deduction. Okay, so now by the introduction of this act, the law makes it very stringent that there cannot be illegal deductions. So which deductions are valid in the eyes of law? The ones which are provided by this act. Okay, so we are going to study the first kind of deduction, that is in terms of fines. Now, fines is also nothing but a way of deduction, right? Is fine a way of when fines are imposed? Can I say it is nothing but one kind of deduction?
Yes, ma'am.
Yes.
Yes,
So
ma'am.
now let us study about fine. Okay. So what does it say? That firstly, fine should be imposed. Just a minute. Let us just admit all the students who are there. Okay. So let us talk about fines. Okay. So in case of fines, fine should be imposed by an employer on employee only with the approval of the state government. Okay, or any prescribed authority. So randomly, the employer cannot impose fine on the employees. Okay, so fine should be imposed by the employer on employee with the approval of the state government or the prescribed authority. Okay, furthermore, employer should follow the rules which are mentioned in this act for imposing fine on the employee. Okay, now obviously, to impose fine, it is very much important that the awareness of the fine is given to the employee, right? So it is very much important that the notice board of fines, okay, on employee should be displayed in a work premises and should contain activities that should not be made by the employee. So obviously, the notice should be put, right? The notice of the same should be put on the premises of the employment, right? In any industry, right? That if you do this, then a fine will be imposed. So notice of the same should be put on the premises of that particular establishment, so that, why do you think this notice is important, students? Why do you think this notice is important? Why do you think the notice is important about the fine in the premises of an establishment, which can be in the railway administration or it can be in the industry? Why do you think this notice is important?
For awareness of people's
For
awareness of people's
for awareness. Very good. Very good, for the awareness of the employees, because if the employees are only not aware, right, about any kind of restriction and any kind of fine which is going to be imposed.
Don't know, then how do they protect?
Correct. If they don't know, then how will they know that a fine is imposed for such kind of conduct, right? So for that
Yes, ma'am.
reason, the notice must be present in the premises of any establishment, that if this act is done, then it was going to lead to a fine, right? So the law makes it very crystal clear that notice must be there. It must be put into the premises of an establishment, so that it creates awareness to the employees. It informs the employees that what they are supposed to do and what they are not supposed to do, and if done, which is going to lead to a fine. Is this clear? Is this clear?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Second of all, let us go ahead. It says that fine should not be imposed on the employee until he gives the explanation and cause for the act of omission he made, right? So what is it trying to say? The law says that it is very much important, very much necessary that a reasonable cause is given to the employee. That why did he omit to do such a thing, right? For example, if you are if your parents have asked you to not to do certain thing, right? If you have done, right, you are given an opportunity to explain the reason why you have done it, right?
Yes,
That's why you did it, right? Same way, my dear students, here the law makes it very crystal clear that if you have done any act which you were not supposed to do, which would have led to an imposition of fine, then in that case scenario, the law says that a reasonable opportunity of being heard must be given to an employee, so that he can say why he committed such an act. Is this clear? Is this clear?
Yes, ma'am.
Yes, ma'am.
Okay. Furthermore, it says that the total amount of the fine should not exceed 3% of his wages. Okay, so if fine needs to be imposed, fine, but it should not exceed 3% of his wages. Okay. Furthermore, fine should not be imposed. Fine should not be imposed on any employee who is under the age of 15 years. Okay, so this is fine. Definitely, we know that it cannot be imposed on minors, right? So it makes it very straightforward that fine should not be imposed on any employee who is under the age of 15 years. Furthermore, fine should be imposed for one time only on the wage of the employee for act or omission which he is done or which is made. It should not be of a continuous nature. For one mistake, it should not happen that he is charged, he is fined again and again. No. If he has made a mistake, then fine should be imposed for only that particular act. He should not be punished again and again by the imposition of fine. Is this clear, students? Is this clear? Is this clear?
Yes, ma'am.
So fine should be imposed for one time only for that particular act. It should not be a reoccurrence again and again that the fine is imposed for one act. Is this clear? Furthermore, fine should not be recovered in way of installments. Okay, suppose a fine of say like 100 rupees has been imposed, so that fine should not be recovered in way of installments, that tomorrow 10 rupees, a day after again more 10 rupees. No, it should be one time payment. So if the fine is of 100 rupees, straightforward that fine of 100 rupees should be paid. Is this clear? So far so good? Furthermore, it says fine should be recovered within 60 days from the date on which the fine were imposed. So what is the maximum time for the payment of fine? What is the maximum time for the payment of fine?
90 days.
60 days.
60
So fine should be recovered within 60 days from the date on which the fine was imposed. So the employer has a right to recover the fine up within it has a time of 60 days to recover the fine from the employee. Is this clear? So the employer has 60 days time to recover the fine from the employee. Is this clear? So this is the time frame within which the employer can recover the fine. Is this clear?
Yes, sir.
Yes, ma'am. Yes, ma'am.
Okay. Now, furthermore, the fine should be imposed on day on which the act or omission was made by the employee. So, what do you mean by this? For example, I have done something which I was not allowed to do, okay, for which the rule says that fine would be imposed, and say I did it on today's day. Can I be imposed on fine for this act after 1 week's time?
No, ma'am.
Yes, ma'am.
Can the employer say, "Oh, I forgot that you had committed a mistake on last Monday, and therefore I'm imposing you fine on today's date"? Can an employer say something like this?
No, ma'am.
So on the day on which, right, a mistake or any kind of act which was committed, which was not supposed to be done, for which the fine is supposed to be imposed, then the fine should be imposed on that particular day itself. You cannot say, okay, last month you had done this, you had done an act which was not allowed, which was committed, which falls under the acts of fine. Therefore, now I am imposing a fine on you. This cannot happen. So, what is important? That fine should be imposed on day of the act or omission made by the employee. Is this clear? You have committed a mistake today, so fine should be imposed on today's date. Is this clear?
Yes, ma'am. Yes, ma'am.
Furthermore, most importantly, what do you think about fines which are being collected? Right? For example, fine is collected from Mr. A, Mr. B, Mr. C. All of them have committed an act which they were not supposed to do, and therefore imposition of fine was levied on them. Now the employer have collected that money. Now how is that money supposed to be used by the employer? Can anyone tell me? Can anyone tell me?
Ma'am, to recover from the damage which occurred.
Yes, so for example, the employees have committed any act which they were not supposed to do, and therefore a fine has been imposed on them. Now the employer has collected that money as fine from the employees, right? Now who has the money of the fine? Employer. Now I want to know, what do you all think? What can the employer do with that money? How is he supposed to use that money? Can he use it for his own purpose?
No.
No, ma'am.
Can the employer go shopping with that money?
No.
No, ma'am.
Why?
No.
Why? What is the problem?
Because this is not his personal money.
Okay, so very good. So here it is very much important that the employer, okay, whatever money has been generated by way of fine, then the employer is supposed to put it under a common fund, okay, and that fund should be used for the benefit of the employees only. It should not be used for the benefit of the employers, okay, or for their self expenses. So this money which is being generated by way of fine, okay, by the employers must be put under a common fund which is supposed to be used for the welfare of the employees. Is this clear? Or for the benefit of the employees? Okay, because this fine is generated by the employees, right? From the employees, right? This fine is generated by the employers from the employees, correct?
Yes, ma'am.
So this fund, this money which is being collected must be used for the benefit or for the welfare of the employees only. Is this clear, students?
I'm just like it is a taxation tax we have pay, and all money is used for us.
Correct. Definitely, it can be interpreted in that way. Yes. So whatever fine which is being collected by the employer must be used for the benefit of the employees only. Is this clear, students? Is this clear?
Yes.
So this was in regard to fines, which is considered as one of the deductions. Okay. Now let us go ahead. Can you all see my screen?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Now we are going to study about deductions for absence from duty. Now we know that if there is an employee who is absent from duty, then obviously the employer will have a right to deduct from his salary because he was absent, right? So if he did not come to work for say from Monday to Saturday, then is employer still responsible to pay him the wage? No. Then obviously the employer is going to deduct it from his salary, right?
Yes, ma'am.
Yes,
Yes or no? For example,
yes, ma'am.
For example, if you all are working, okay, or if you've seen your parents work, for the days you don't go to work, okay, does the employer still pay for the days that you have not come to work?
No, ma'am.
No. So these are nothing but deductions, right? So these are also considered as deductions under section 9. Okay. So we are studying about deductions for absence from duty. So now here, my dear students, now deductions can be made by the employer for the absence of duty by the employee for 1 day or for any period. So for example, if the employee did not come to work for say 1 day, does employer have a right to deduct that day's wage?
Yes.
Yes. Say now the employer did not come to work for say 10 days. Does the employer have a right to deduct 10 days wage?
Yes. 10 days wage will be
Yes.
deducted.
Correct. So the employers definitely have a right to deduct wages if the employee fails to come for work or there is an absence from duty from the employee's side, right? Furthermore, so if he is coming, there is an absence of 1 day, then obviously the deduction of the wage is going to be for 1 day. If that is then absence for 10 days or 15 days, then obviously deductions are going to be for those 10 or 15 days, right?
Right, ma'am.
Right. Now, furthermore, the amount deducted for the absence from the duty should not exceed the sum which bears the same relationship to the wage payable in respect of the wage period, as this period of absence does not thus to such period. So, what do you mean by that? It means that the deductions, okay, so if the deductions are being made by the employer, okay, it should not exceed his wage salary. For example, if the salary of an employee is 6,000 okay, per month and he is absent for duty for 1 month, okay, so deductions from the salary for the absence of the duty should not be more than 6 months. Is it clear, students? Is it clear? clear?
Yes, ma'am. Yes, ma'am.
So what is it trying to say? That if it should not exceed the salary, the deduction should not exceed the salary. For example, the salary is only say 6,000 per month, and if the employee does not come for a month's time, so what does the law say? That the reduction, okay, cannot be more than 6,000 rupees. Is this clear?
Okay, ma'am.
Yes, ma'am.
Okay. I think there is a background noise from, I think, Irshad.
Yes, ma'am.
Can you please mute yourself? I think there is
Okay.
a background noise from your end. Can you?
Okay, ma'am.
Yeah. Okay. Now, let us go ahead. It further says that employee present for the workplace, okay, and most importantly, refuses to work without proper reason shall be deemed to be absent from the duty. So what does it mean? That he has come, the employee has come to the workplace, right? But he is not performing his duty, he is not working. Then in such case scenario, will he be paid wages, or do you think there will be deduction from his wages?
Ma'am, deduction from his wages.
There will be deduction because there will be deduction, right? Because if he's coming, but if he's not working, right? Then in such case scenario also there will be definitely be deductions. Say that he is conducting any strike. He's come to work, right? But he is imposing any strike, not working. He's not carrying out his work. Then in such case scenario, definitely there can be the employer has a right for deductions for his absence. Okay. Furthermore, if 10 or more persons together are absent for the duty without any notice and without any reasonable cause, then in that case scenario as well, my dear students, employer can make 8 days of wage as deduction from their wages. Okay, so this is also permissible. Okay, so if there are more than 10 people together, they are absent. Okay, they don't come to work. Okay, and which is without any notice. They don't inform the employer, okay, about the reason, or they don't even acknowledge about that about their leave of absence to the employer. Then in that case scenario, employer can make 8 days of wage as deduction from their wages. So this is permissible and this is legal. Is this clear, students? Is this clear?
Yes, ma'am. Yes, ma'am.
Now, having understood, great. Now, having understood about deductions for absence from duty, we are going to go ahead and study about deductions for damage or loss. Okay, we know that deductions are also lawful when it comes in regard to a damage of loss. For example, that if there is any machinery, okay, and employee, okay, purposely he damages the machinery, then in that case scenario, will the employer have a right for lawful deductions?
Yes, ma'am.
Yes. Obviously, why? Because he has purposely damaged the machinery. So, okay. So, obviously, the employer in such case scenario will have a right for lawful deduction. Right? So, what does it say? It says employer should give when in such, if any of thing of such damage of loss is happening, definitely deductions can be are going to be considered as lawful, right? So deduction for a damage to or loss of goods expressly entrusted to the employed person for a custody or for a loss of money which he is required to account can be made where such loss is directly attributable to his neglect or default. So if the employer has given a custody of any goods and have asked the employee to take care of it, okay, and he negligently or intentionally damages it, then in scenario, definitely the employer will have a right for lawful deduction. Okay. Moreover, a deduction for damage or loss shall not exceed the amount of damage or loss caused to the employer by his neglect or default. So obviously we know that the deductions definitely for the damage or loss, it should not exceed the amount of damage. For example, say that the amount, of that machinery was say 1,000 rupees, right? So deductions cannot exceed more than the damage. If a particle of that is damaged, right? Machinery, a part of that machinery is damaged, and that expense is say only of say 500 rupees. Then in that case scenario, the deductions cannot be more than 500 rupees. Is this clear, students? Is
Yes,
this
ma'am.
clear? Furthermore, a deduction for the damage or loss shall not be made until the employed person has given an opportunity of showing cause against the deduction. So obviously, if the employer has committed any damage, right, then he should be given an opportunity of being heard that how did that damage occur. So definitely employee must be given a reasonable opportunity of being heard. Okay. And lastly, all deductions and realization in respect of damage or loss shall be recorded in the register to be kept by a person responsible for the payment of wages. So it is very much important that a register is maintained wherein all the deductions in respect of damages are recorded. Is this clear? So maintaining of this register by the employer is also important. Is this clear, my dear students? Are you
Yes,
all
ma'am.
with me? Great. Now let us study about deductions for accommodation and services. We have studied that yes, if accommodations have been provided and which has been accommodations and services which are being provided by the employers and which has been accepted by the employees, then in that case scenario, deductions are also going to be considered as valid. Okay. So here we know that when we are talking about these deductions, then definitely deductions for house accommodation and amenities and services supplied by the employer can be made definitely subject to certain conditions. What are those conditions? That deductions cannot be made unless such service have been accepted by the employed person as a term of his employment. So first and foremost, for deductions, it is very much important that these services are accepted by the employee, right? If these services of house accommodations, right, if that is only not accepted, then can the employer impose deductions on employees?
No, ma'am.
No, because the services are only not taken by the employees, right? Then why will they the employers? Then how can they that be deductions, right? So it is very much most importantly, it is trying to say that deductions can only be imposed if these services first and foremost have been accepted by the employees, right? If they have taken the service of accommodation, right, then in such case scenario only the deductions are going to be imposed. Is this clear?
Yes, ma'am.
Okay, now furthermore it says services do not include supply of tools or raw materials required for the purpose of employment and no deduction can be made in that respect. So here services does not include the supply of tools and raw materials. So that is definitely not going to come under services. Okay. Furthermore, the amount of deduction cannot exceed an amount equivalent to the value of the house accommodation, amenity or service supplied. Same rule. Obviously, the deduction cannot exceed the amount equivalent to the value of house accommodation or amenity or for which service is being supplied. Right? And lastly, the amenities and services must be authorized by the state government by a general or special order. Okay? So, always remember, students, the role of the state government plays, the state government plays a very important role. Okay? So, amenities and services the services which are being provided by the employer, okay, those must be authorized by the state government by a general or a special order. Is this clear?
Yes, ma'am.
Okay. And lastly, the state government are empowered to make rules governing the deductions for amenities and services as well. Is this clear, my dear students? Is this clear?
Yes, ma'am.
Yes, ma'am.
So this was in regard to deductions for accommodations and services. Okay. Now we are going to talk about deductions for the recovery of advance. Advances are nothing but something which is like a loan, right? So obviously, if a kind of advances have been given by the employer to an employee, then obviously he will have a right to recover that amount, right?
Yes.
Right? So for example, say an advance of rupees, say 5,000 was taken by an employee, right, from the employer. Then obviously the employer will have a right to that 5,000 rupees. Correct?
Yes, ma'am.
Will he have a right or no to that 5,000 rupees? Students, are you with me? My question is, if the employee has taken an advance of say 5,000 rupees from the employer, then will the employer have a right to that 5,000 rupees? Will he have a right to take back that 5,000 rupees or no? Or is it a gift or a charity?
Yes, ma'am.
Yes, ma'am.
Yes, so he will definitely have a right, right? So now what will the employer do? To get that money, he will deduct it from the wage or the salary, right? So is this allowed? Is this valid?
Yes, ma'am.
Yes,
Yes,
ma'am.
so this is definitely valid under section 12. It says reductions for the recovery of advances or adjustments of overpayment of wages can be made subject to the following conditions. First thing, recovery of an advance of money given before employment. Okay, this pay attention about the wordings. Okay, recovery of an advance of money given before employment. So before the person came into how the money is going to be recovered. Okay, so the recovery of an advance of money given before employment shall be made from the first payment of wages. So if the person has newly joined in, then from his first payment, that deductions can be made towards advances. Is this clear? Is this clear?
Yes.
But
Yes.
important thing to remember is that but no recovery can be made of such advance given for the traveling expenses. So from traveling expenses, you cannot have any deduction. Okay, is this clear? Is it clear, students?
Yes, ma'am.
Sorry,
Yes,
ma'am.
ma'am.
So further,
मैम एक मिनट मैम, इसमें जो है ट्रैवलिंग एक्सपेंस वो जो पहले दे रहा है सर्विस ज्वाइन करने से पहले, वो रिकवर नहीं होगा, या फिर सर्विस में आने के बाद अगर उसको ट्रैवलिंग एक्सपेंस देते हैं तो
yes,
वो तो रिकवर होना चाहिए।
yes, नहीं, अब द एम्प्लॉयर जो है वो डिडक्शंस के रूप में वो वहाँ उससे पैसे नहीं ले सकता ट्रैवलिंग के।
अगर हम किसी को टीए देते हैं मैडम, ट्रैवलिंग अलाउंस देते हैं किसी को, तो वो रिकवर
वो एम्प्लॉयर देता है एम्प्लॉय को,
हाँ, वो डिडक्शन तो नहीं है।
करेक्ट, पर एम्प्लॉयर उसको डिडक्शन के उसमें से वो ले नहीं सकता वो ट्रैवलिंग अलाउंस।
ओके,
For the safeguard of the interest of the employee, so that he cannot take it from the employee. Is this
अगर मैडम ज्यादा दे दिया है उसको तो वी कैन रिकवर दैट।
अगर ज्यादा दे दिया तो, so if there is an overpayment, if you see, if there is an overpayment, then yes, but otherwise he cannot just take that traveling allowance from him
फाइन
as deduction. Is this clear?
ओके,
Yes, ma'am.
So recovery of an advance of money given before employment shall be made from the first payment of the wages in respect of complete wage period, but no recovery can be made of such advance given for traveling expenses. Is this clear? Is it clear?
Yes, ma'am.
Okay. Further, recovery of an advance of money given after employment. Then in that case scenario, what is going to happen after employment? In case of after employment, what will happen? Recovery of an advance of money given after employment shall subject to such condition as the state government may impose. In that case scenario, whatever the state government prescribes, that will follow. Okay. And lastly, recovery of advances of wages not already earned shall be subject to any rules made by the state government in this regard. So again, the direction of the state government is also going to be of vital importance here. Okay, so the state government may regulate to the extent to which such advances may be given, installments by which they may be recovered, and obviously the rate of interest that may be charged on such advances. So the role and the power of the state government here, it is extensive. Is this clear? So in such case scenario, the state government will have a right, okay, about to what extent the rate of interest must be charged, in what installments the advances must be paid back to the employer. All that rules and regulations, the state government will have a power to make. Is this clear? The state government will have those power to make rules in that regard. Is this clear, students? Is it clear?
Yes, ma'am.
Great. Now let us go ahead and talk about deductions for recovery of loans. So when a loan is taken, okay, by the employee from the employer, then in such case scenario, if the employer to recover the loan amount from the employee, if he is deducting that amount from his wages, will that be considered as valid? The answer is again yes. It is valid under section 28. Great. It says that deductions for the recovery of loan made from any fund constituted for the welfare of labor and the interest due in respect thereof can be made provided the fund is constituted in accordance with the rules approved by the state government. So yes, if the laborers are there who are in need of money, definitely the employers have a right to give loans to such laborers out of that fund. Okay. Now, furthermore, when we talk about deductions can be made for recovery of loans granted for house building or other purposes approved by the state government and the interest due in respect of thereof. Many a times the laborers which are there, they need money, so they take loan from the employers, right? Now, from where does the employer give the loan to the employees? From the fund which is kept separately for the laborers itself. So now when the employers are giving loans to the employees, then in that case scenario, what is the law saying? The employers will have a right to recover that loan by way of deduction. So those deductions are definitely going to be considered as valid deductions in the eyes of law. Is this clear? Is this clear, my dear students? And when we talk about the rate of interest, okay, that definitely is going to be as per the rules which has been laid down by the state government. Is this clear? Is it clear, students? Great. Great. Now let us talk about deductions for the payment to cooperative societies and insurance schemes. So we know that the deductions can also be in the form of payment of cooperative societies and insurance schemes, right? So such deductions, if they are made by the employers, okay, those deductions are going to be considered as valid. For example, if there is any insurance scheme, okay, like you all know that from the salary, certain amount goes to the provident fund, right? Something which it is for insurance purpose, right? So from that wage, if the deductions are made towards any insurance scheme, those deductions are also going to be considered as valid deductions. Is this clear? Is this clear, students?
Yes, ma'am. जी.
Great. Now, there are, so this was completely in regard to deductions, okay? And there are other deductions as well, but these are the most important vital deductions, okay? Now, we have studied about the most important deductions, okay? Now, apart from that, always remember, students, that when the employers are deducting wages, okay, then in that case scenario, it is very much important that employers maintain a register and records about it, like about the deductions. So this is a very important role of the employers. It is very much important, very much vital that a book, a register nothing but a book, a register is maintained wherein a record of all the deductions are listed. Okay, so I believe it's your break time now. Okay, so what we will do is we will start with section 13A after your break. Okay, so after you come back from your break, we are going to study about maintenance of the register. We are going to talk about inspectors and their powers. We are going to talk about the powers of the inspectors. We will study about the appointment of competent authority. So all this we are going to study after your break of 15 minutes. So far, did you all understand about deductions? Which deductions are valid in the eyes of law? Is it clear to one and all?
Yes,
Which reductions, which imposed by the employers will be considered as valid? Great. So what are we going to do is, once you come back after your break, we will quickly revise it, okay, for 2 minutes, and then we are going to go ahead with the next topic. Is it clear? So do you have any questions or any queries?
Yes, ma'am.
Yes.
Ma'am, good afternoon.
Good afternoon.
Ma'am, this is a bit out of the box.
Hmm.
Ma'am, I just want to ask you that since our exams are just 3-4 months away, so ma'am, like if we get a 5-mark question, for instance, wherein we are supposed to, write a short note on something, for instance, minimum wages or fixation of wages or whatever, right? So ma'am, how do you want us to go about with a 5-marker, as in how many case laws do you expect us to include in a 5-mark question, as in 3, 4?
Yeah.
Or,
See, okay, I will explain this. So, for example, you are asking me, let me take an example of reductions. Okay, deductions
Yeah, sure.
under the Payment of Wages Act. If that topic of deductions is asked for 5 marks, then how will you get 5 marks completely? Right, the full 5 marks. Then in that case scenario, I would expect you to write the provisions. First, what are deductions? Right? Then what is actually you think are deductions but are not deductions in the eyes of law. For example, if there is a demotion, can that be considered as deduction?
No.
No. If there is an increment which is not being given to the employee, is that deduction? No.
No.
Right?
No.
Correct.
Yes, ma'am.
So I would want you to explain me what is deduction very properly, right? What is actually not considered as deductions, okay? Which people may think that is deduction, but obviously those are not deductions because now you have studied the provisions. And after that, I would like you to give me what are valid deductions in the eyes of law. Okay, so for 5 marks, I would at least want you to give me, for example, we studied about fines. We know the entire list which are valid deductions, right? So if it is for 5 marks, I would at least want you to give me list down at least minimum 5 deductions. Okay, so that is more than enough. if it is a
Right.
short note. But if it is a long question, okay, then in that case scenario, I will definitely expect a long answer, wherein it would be very much important to mention about all the deductions. Is it
Alright.
clear?
Another question. Yes, ma'am. That's right. That's right. Another question, ma'am. Ma'am, since we are studying the old acts as of now, and since the new code has been incorporated, although it has not come into effect, so ma'am, I have this doubt that while attempting a question in the assignment or while writing the answer for an exam, ma'am, if we are mentioning a particular section of that respective act, right? We have described the provision and whatever the question is asking, we have written that. And while concluding the answer, if for instance we mention that, okay, as according to the new, so and so code, this change has been incorporated, can we conclude the answer including that?
Yes, of course.
Definitely. Yeah, because even in the other subjects, our faculty has said that you can definitely conclude your answer saying that under the new code, the new thing has been incorporated. So it will give a touch to your answer. You can do this, right?
Definitely. So see here, whenever you are writing an examination, right?
Right.
What we do is we see how well you have studied, right? So if you are giving this further information, then definitely that is going to count,
That is
because you are making an analysis at the end.
Yeah.
Yes.
Ma'am, that is also
Pardon me?
all going to give a touch to our answers.
Yes, that is like you are giving an analysis of your answer at the end. Like, what do you think?
Right.
So if you can even give I would say you can also give an analysis. So if a new code has come and if I've given new rules and regulations, right? So what do you think about it? Do you think it is pari materia, or do you think it is in conflict? So you can also conclude with your analysis. You can also conclude it in that way. That is, in
so
fact,
ma'am-
more appreciable.
Yeah, so that is what my query was. So for instance, if we are giving the definition of minimum wage, for instance, right? So after describing what the Minimum Wages Act say, we can also write that, okay, according to the Code of Wages, now the wages have been defined as so and so and so. So we can write that also, right?
Correct.
At the end, right?
Yes, in fact, yes, of course. In fact, like we have studied different definitions under minimum wages by different jurists as well. So you can also write about those other jurists. So that is also permissible. See, when you are writing an examination, okay, you have to write it in such a way that whatever knowledge you have of that particular topic, okay,
Yeah.
in that particular time frame, you should just put it into words.
Right, ma'am. Very right.
So this is what you are supposed to do. This is how you will fetch more marks, I would say.
Right, ma'am. Ma'am, another query. Ma'am, since I was just going through the...
Okay. What I will do is I will have this question answer round maybe after the break time, because your break time has already started. So let me do one thing. When you come back, I will solve all your queries. Is that fine?
Sure, ma'am. I'll get back to you after the break. I'll definitely get back.
Oh, yeah.
Right. Thank
So
you.
I see that. Most welcome. So rest of all the students who have any questions or queries, I will resolve them after the break. Okay. So please, I believe 5 minutes have already passed. So please enjoy your break for the next 10 minutes, and then we shall come back, and then I will answer all your questions. Okay. So please enjoy your break time. Thank you, class. And just 1 minute, I'm quickly going to download your attendance.